How did you get involved in this particular area of the law? Tell me what guided you in this direction.
I was prosecutor, pretty routinely criticizing judges for how they were treating abused women and children, in the sense that they were ordering them to do things that they weren't ordering robbery victims to do. Most significantly, they were ordering them to turn over years' worth of counseling records, pediatric records, school records, even though they weren't relevant and significantly predated the crime. And I just kept criticizing the court for treating these victims differently than other victims of other kinds of crimes. And it was irrational to me. And one day a judge said to me, he pulled his glasses down from his nose and said, "Ms. Murphy, you are the government. Your job is to state the law, not complain about it. If you want to change the law, you have to get a different job." And I guess that was the inspiration, because I thought, wow, I'm the prosecutor. I think it's my job to stand up for victims when they're being mistreated. But this judge has just told me that's not my job. So I do need to get a different job. And I literally left the DA's office as a prosecutor later that year and started doing pro bono work for victims, figuring this was a missing voice, if you will, in the system, and that they needed to be heard. They needed to be in that courtroom objecting and saying, "You're not treating me fairly. It's not right for you to treat me, because I'm a woman or a child, differently than you're treating the victim of a robbery or the eyewitness to a carjacking." So when I started that part of my career, it was, again, all pro bono, because most victims don't have any money. And I told my husband at the time, I'm just going to do this for a year or so, and then I'll get a real job. And that was about 30 years ago, and I've been doing pro bono work ever since.
What is the mentality? Does this go back to the 14th Amendment, never really including women? Or, I mean, is it that most judges are men? Because as you know, when I had a real job before Dr. Phil, it was in the litigation arena. And I was many times court appointed as a trial scientist to be involved in criminal cases on a pro bono basis. And I saw exactly what you're seeing, where there was clearly a double standard and they were required to produce all of this information, which was just so much ammunition for the other side to drag up irrelevant pre-crime information to impeach the veracity of the victim and use it against them. Where are the roots of that? Why is that going on? And it's still going on.
The 14th Amendment, we all know and love as a really important constitutional amendment that was adopted by this country in 1869. And it guarantees all of us equal protection of law and due process of law. The problem is, pretty quickly after that was adopted, the Supreme Court of the United States decided that women and only women were not covered by the 14th Amendment, that the 14th Amendment was really only meant to protect Black men. So women of all colors and stripes were excluded from really the most important constitutional protections in our laws, in our most foundational laws, equal justice. Equal justice was denied women in 1869, and we still don't have it. That's what gives the judges permission and the power to say, it doesn't matter, Attorney Murphy or Dr. Phil, if you don't think this looks right, because we're giving, better protection to other types of crime victims and we're mistreating women and children who've been abused. It doesn't matter that you think that's not fair. It may not be fair, but it's constitutional. And until we fix the 14th Amendment, it will continue to be constitutional. And that's why we've been fighting for the Equal Rights Amendment for over 100 years. The Equal Rights Amendment is really the repair of the 14th Amendment. It literally says you have to give women equal protection of law because you left them out of the 14th Amendment. The Equal Rights Amendment, many people don't even know about. It was first passed by Congress in 1972. We never had it ratified by a sufficient number of states. And, the important part of this story is that we need to get the word out. We need to get the word out that not having equal protection of law manifests itself in very real ways and causes suffering in the name of justice in ways that you described and in ways that I've been experiencing for decades.
And see, that's the thing. And I think there are a lot of people, men and women, but women that get victimized by it, are not aware that women do not have equal protection under the law. They don't have it constitutionally, and they don't have it pragmatically. And you don't realize that until you wind up in the court system and there's somebody up there saying, HIPAA be damned, confidentiality be damned, and all of the rules of evidence that apply in other crimes all of a sudden are thrown out the window.
Right.
And all of these things that you can't bring up in a robbery case or you can't bring up in a murder case about pre-offense information that never gets in front of a jury, all of a sudden is paraded out in front of the jury about a victim that has been brutally raped. They can now talk about what she did in high school, what she did in college, what she did at a party 3 weeks before this happened. And you're sitting there saying, wait a minute, this predated the offense. What the hell does this have to do with what happened that night?
Yep.
But yet it's admitted and it's not reversed on appeal when it is clear violation of the rules of evidence. So
Yep.
It doesn't happen just at the trial level, it's upheld at the appellate level.
I was representing a woman who'd been nearly killed by a man who had also brutally raped and killed other women. And she was brave enough to testify against him, and he demanded access to her counseling records that predated this man's brutal assault of her. We fought like hell to stop those records from being turned over because when she had therapy, she was told by her therapist that was a private session, that what she was saying was confidential, and she needed that promise of confidentiality in order to be open about her feelings and to get better. But the judge basically, and when I challenged the judge who ordered the records turned over, I said, what does this have to do with anything about what happened the night he beat her? Why aren't you ordering her to turn over her grocery receipts if you don't care about relevancy, right? The judge slammed his gavel and said, Ms. Murphy, if you keep talking, I'm going to dismiss the charges and this man will walk free. That's what it came to. So my client started sobbing. She begged me to give him anything he wants. If this man gets out of jail, he's going to kill me. Please just give him my counseling records. So we did. And in the records, there was a description of her being sexually abused by her dad when she was a little girl. No one knew about it. Her family didn't know. And of course, what did that man use as evidence during the trial? That she had been sexually abused by her father, and she was now falsely accusing him in order to avenge her childhood experience. She ended up winning the case, but what a price to pay that had to be revealed to the whole world, because the news was covering the case. Her family found out. Everyone learned something that should have been confidential, had nothing to do with the case, was deeply personal to her. And that's a price for justice that we only impose on women, and it's outrageous.
You and I were in a conversation, I don't know, maybe a month ago, and Warren Farrell was there. And I guess he's called the father of the men's rights movement. And you had a lot of issues with what Warren Farrell had to say, including that men need a movement. In fact, you said to call a men's rights movement a movement is part of the problem, that a movement is attached to an underclass, and it's very difficult to hear white men say they are enduring any kind of structural harm.
He talks a lot about the fact that men are culturally forced into very strict roles where they're not allowed to be emotional or raise the children. They are only valued for how much money they make. I agree with him about that. I think it's terrible that men are valued only based on how much money they make and whether they are expressing their masculinity in an aggressive and rough manly way. I think that's probably where we have common ground. Where I disagree with him strongly is the idea that the solution to that problem is a men's rights movement, because really men have had supremacy in this country since the beginning. And as I mentioned earlier, in 1869, the Constitution declared men supreme under the 14th Amendment. And until we fix that, until women are actually equal humans, equal citizens in this country, I think it's just offensive to have a men's rights movement. Let's get women equal first, and then, whatever movements we have we can at least be at a level playing field.
He was saying that women have a choice to be a mother or a professional or both. And you said he's 100% wrong. Why do you say that?
Well, first of all, women are not just in these two boxes. I think women are much more complicated and interesting people than just mothers or workers. And also, as a mother and a worker, and a lot of other things. I go fishing and I hang tile and I enjoy hot yoga. I think to think of women as multidimensional is important, but it's also really important not to put them in this dichotomous choice, because by definition, if you only can be one thing or the other, then when you're choosing one thing, you're doing harm to the other, and vice versa. And enormous numbers of women in this country are very happily doing a lot of things. Some of the time they are focused on their families. Some of the time they're focused on their work. Some of the time they're doing both things at the same time. I mean, I've brought my newborn to court during a jury trial. I asked a judge for a break so I could breastfeed her. She was only 2 weeks old. I had to induce the birth of my 5th child so that I could, on a Sunday night, so that I could get to the Supreme Court in my state Wednesday morning with a 2.5-day-old baby in tow.
Whoa, wait a minute. That didn't sound like a whole lot when you said it real fast, but hold on. You induced your 5th child and then took it to court 2.5 days later?
I did. I had to, because the court knew that I was pregnant and they ordered me to be at the hearing at the Supreme Court. So my baby didn't come out by Sunday night. I asked my doctor, please, she was overdue. So she was quite cooked, ready to come out. But she wasn't out by Sunday night. I asked my doctor to please induce me. Because assuming everything went well, I would get out of the hospital Tuesday afternoon and be able to get to court with her, because obviously I was a nursing mom, Wednesday morning. And that's exactly what I did. She was 2.5 days old. And I was arguing the case completely exhausted, still wearing maternity clothes, brain dead, but it had to be done. So, I mentioned that only because it's what we do as women. And men do it too. I don't mean to make this just a women's issue. Men do it too. They just don't do it as much, and they don't do it with the same intensity because they haven't had the primary responsibility as a caregiver to the kids for a long time. That many more men do today, obviously, than ever before. But the fact is, we have a very busy society where these days you almost always have to have both parents working. That means if you want to have a family, you're doing lots of things at all times. And you have to ask your family to bend a little when your work intrudes in their space. And you have to ask your work to bend a little and allow your family to intrude sometimes. There's no other way to make it happen. We can't be binary about this. We can't only be parents or workers. We have to be more sophisticated about how we see the overlapping demands on our times. And that goes for men and women.
Yeah, but 2.5 days, that's pretty astounding.
Well, I brought a babysitter. I didn't bring her and plop her in the chair next to me. I brought 2 babysitters. She was really quiet during the hearing, except when my opposing counsel insulted me and she screeched. And then she went back to sleep again. I think it was meant to be. It was fine. There are women who, if you have babies and you're a lawyer, Your clients need you, and the courts are not very accommodating. They just aren't. I wasn't going to indulge them. I was going to accommodate myself and do what I had to do. And that includes yelling at the courts sometimes. I had a judge say to me once when a jury was out deliberating, 2 of my children were in daycare, and I had to go pick them up. And she said, the jury wants to stay late tonight because they're going to have a verdict. And I said, but I have to go get my children at daycare. And she said, oh, well, here, use my phone and you can make a call. And I said, who do you think I'm calling? Like, I'm going to get my children. I don't have anyone to call. And you will tell the jury to either come back now or come back tomorrow. But I am not going to leave my children at daycare because the jury feels like staying late. And the jury came back right away and they had a guilty verdict and everybody was happy and it was fine. But, women do have to say, listen, this is part of who I am as a lawyer, and you, judge, are going to have to accommodate me in some fashion. It's not a disability. It's just part of life. It's how we recreate as a species, and you have to accommodate this. You just have
of course.
to.